back to Litigation Help. My name is Helena Birt. Today, we're going to talk about how family property is shared in Ontario after a relationship breaks down. Okay, so last year, family lawyer Helena Birt and I touched on the subject of matrimonial home in another video. And you can watch that video by clicking on the little I button above. And I'm so glad that Helena's back with us again today. Hi, Helena.
Hey, Heather, how are you?
Great. So today's video, I've asked Helena to explain how property division works in a little bit more detail using a few hypotheticals or scenarios. So we're actually getting a little bit technical today. We're also going to be using the actual Ontario court forms to show how equalization calculations are done. Now, these forms are free to download on the Ontario court site, and I'll have the link for that in the description box below. Okay, Helena, so let's begin. So before we go to the hypotheticals, let's just go through a little bit of a refresher. So what is the basic idea behind how property is dealt with when a couple separates in Ontario?
Okay, the reason why we're doing this with a number of different hypotheticals is because there are different rules that apply depending on the property that you're talking about. And the big exception is going to be the matrimonial home. So keep that in mind. So we'll define what matrimonial home is, and then we'll work through it on the examples. But generally, and the reason why we are limiting it to Ontario is because the rule in Ontario is if a couple is married and they separate, okay, any property that's accumulated during the marriage or any property that is increased in value during the marriage is to be shared. And the way that is defined in the legislation in Ontario is that each party is entitled to an equalization of their net family properties. So it basically becomes an accounting function, because what you're looking at doing is saying whatever a party has in the way of property, and if their property is worth more on the date of separation than it was on the date of marriage, then that value, whether it's in their name alone or if it's owned jointly with the other party, it gets shared between the parties, because the basic rule where they started this is that a marriage is not only a familial relationship, it's also an economic relationship. So even though you might just have one party that might be paying the mortgage and the taxes and the bills and the loan on the car, it's still all property that was accumulated during the marriage. Not party may not have been able to get that property if it wasn't for the other party pulling their weight and paying utilities and bills and groceries and everything else. So that's why the decision was made in Ontario that if you are married, when you separate, if your property is increased in value through the marriage, the general rule set out in the Family Law Act is that the property must be equalized. But again, we'll go through exactly what this means, because the actual phrase is an equalization of net family properties. Now, the key trigger to keep in mind as well with what we just talked about is for the purposes of an equalization of net family properties, the Family Law Act defines spouse as a person who is legally married. So everything that we're talking about now for property division and an equalization of net family properties only applies if you are married. It doesn't apply if you're in a common law situation and you're separating. And that's a whole topic for a whole other day. So again, we're keeping in mind, we're talking about this is the basic rule that comes into play in Ontario when you are married. The other trigger to keep in mind, this is Ontario. There are other provinces in Canada where they've gone a different route, where they've expanded the definition of spouse to say that if you're in a long-term cohabitation relationship, then property will get equalized the same way in a common law relationship as it does in a marriage situation. So again, what I'm talking about today specifically only applies if you're in Ontario, and it only applies if you're married. So that's where the basis came from. Basically, to do a net equalization of net family properties is an accounting function, which again is what you're going to hear. Even a lot of lawyers that do this and are very, very experienced, they usually have an accountant or a financial specialist on tap in the background. All right, so what we are looking at doing, if you are a spouse who is separated and you live in Ontario, is what the Family Law Act says you're entitled to is an equalization of net family properties. So let's break that down piece by piece. So the first thing we're looking at is equalizing, which means that property that's accumulated during the course of the marriage, the net value of that property gets split 50-50. Doesn't matter whose name the property is in, if it's property that was purchased during the marriage or increased in value during the marriage, that increase or the value of that new property will be equalized. It gets split 50-50. Next really important point, we're talking about the value of those the net family property. We're not talking about equalizing the actual assets. It doesn't mean that because you may own, and we'll get back to the matrimonial home later, but let's say it's the biggest thing. You may own a house that's all in your name. You don't have to put your spouse on title to show that they're entitled to half the house. What you do is you claim the total value of the house, and it is that value. So it falls into the calculation. So your spouse is going to be entitled to the equity in the house that accumulated during the marriage, but not the house itself. So again, you're just talking about figuring out the values, and then you're doing a money equalization afterwards. So we're talking about value, not an equalization of property, but an equalization in the value of the properties. Then you get into the definition of what exactly is your net family property. And this takes you into the section about how you do those calculations. It is set out in the Family Law Act. It's an accounting function, which again, and I've said this before, this is why a lot of family lawyers actually do have an accountant or a financial advisor on retainer, or somebody that they can get in to help if the property calculations are starting to get a little bit calculated or difficult to figure out, because they might need help with this because it's an accounting function. So to take it down to the simplest level, how do you calculate your net family property? So the first thing you do is you start out and you take each party. So we're going to be talking about two spouses here. I think this is the first time we're introducing Sandy and Robin, right?
Yes,
okay.
that's right.
Sandy is spouse A, Robin is spouse B.
Yeah.
We are trying to keep this completely gender free. If you are in a homosexual marriage, it doesn't matter. If you are legally married to each other, you're entitled to an equalization of net family properties. And our spouses are Sandy and Robin. And you can make them look like whatever you see in your head, but we're just going to refer to them as spouse A and spouse B, or Sandy and Robin. So each of Sandy and Robin, on their financial statement, their Form 13-1, they will go through on the property section. And the first thing they're going to do is each of them will list on their financial statement what every piece of property they own on the date of separation, what that property is worth. And what that means, it's fair market value. So it's, if you said on the date of separation, you take a snapshot of what Sandy owns. And if Sandy sold everything that he or she owns on that day, how much money would they get for it? And that's the value of what goes in for the value of property on the date of separation. Sandy does that, Robin does that. The next step in the calculation is, once you figured out what the total gross value of all your property is on the date of separation, then each party has to go through and say, okay, what debts do I owe on the date of separation? Because you're talking about net properties, right? Yep. So if somebody's going to share in the value of the property, they're also going to have to take the hit on if you've got debts and expenses. So you do the same thing for debts. What debts did you owe money's worth on the date of separation? If the property or the debt is all in your name, like if you've got a bank loan and a car, and the bank loan and the car are both in your names, you would claim 100% of that on your financial statement. If Sandy and Robin had both their names on the car and both the names on the bank loan, they would each claim half, because you're actually claiming what you legally own, what you legally owe. And it all is dependent on whose name is the debt or the property in. So once you go through that exercise, then you know what the value of your net family properties are on the date of separation. But you're not finished, because most people don't come into a marriage with absolutely nothing to their name. They've already got property. They may have investments. They may have a car. They may have a boat. They may have a house. They may have a motorcycle. Mm-hmm. And they're coming in with that into the marriage. And they're entitled, each party is entitled to claim a credit for the value of property they owned on the date of marriage. So you go through exactly the same exercise. Each party has to do their own for what they actually owned in the way of assets on the date of marriage, and what they owed in the way of debts. So then once you go through that process for the date of marriage, you've got the value of the net family property on the date of marriage. So that's the next step. Once you get that all done, you've got what your net property is worth on the date of separation. Subtract out the net value of your property that you had on the date of marriage, because you only have to share increases in value, right? So you're only looking at what accumulated during the course of the marriage, with one exception, which is the final step when you're doing this calculation, which is, do you have property that is excluded property? And again, all this is defined in the Family Law Act, and you go through this, and that's the final adjustment you make to get the final drop down number of what your net family property is that needs to be equalized, because excluded property is defined as any property that you receive during the course of the marriage that the Family Law Act says you don't have to count as family property. So that could be, for example, anything that you receive by way of a gift or an inheritance. Like, let's say that 3 years, and we're going to be seeing this in our scenario. Sandy's mom dies and leaves him a Picasso, and that Picasso is worth lots and lots of money. But if that was a gift to Sandy alone, it was a gift just strictly to Sandy. It was inherited during the course of the marriage.
Mhm.
It's going to be property that he claimed as part of the assets that he owned on the date of separation,
Mhm.
but he gets to take that out because it's excluded property. He doesn't have to share the value of property that he received by way of a gift or an inheritance. Other things that come in to play under those things, other than gifts or inheritances, is that if you receive proceeds of settlement from like a motor vehicle accident, or if you've won a civil litigation case. So it gets kind of technical about what those kind of things are, but it's basically something that is defined in the Family Law Act as excluded property, and motor vehicle accident proceeds count. Like if you had gotten hurt and you did get like $100,000 in settlement proceeds from a motor vehicle accident, as long as you took that money and you kept it separate and you kept it for yourself in a bank account, like under your own name, you can claim as excluded property. Again, it starts getting a little bit tricky if you take that money and you dump it into a joint bank account, or you use it to buy a car, then it starts getting a little bit iffy, which is why when we're talking about property, we generally do tell people it's really a good idea to get a lawyer and also have a financial advisor involved anyway. But assuming we're not going to get that complicated, that's in a nutshell how you do the calculations for the equalization of net family properties. It's the net value of property on date of separation, which is assets less debts.
Mhm.
Then you get to deduct out the value of what you had on a net basis going into the marriage. And then is there anything you can take out of the value of assets on the date of separation that is excluded, because you don't have to share that with the other party.